I'd like to just hand up as Exhibit B a further affidavit which has been done relating to some of the allegations that apparently the state wished to raise in regards to this matter, and I think it will set out and deal with it. I was present when Mr. Agrizzi signed it. It was commissioned by the court orderly, and I have provided a copy, which is obviously the right way to do things, to my learned friend, so that they've got a copy of everything. Whatever we're handing into court, we give to the state, so that there's no issues, the way it should be done. So they have got a copy.
Before you proceed with this replying affidavit, can we just attend to the affidavits? It was the second one that you read out, which you said you had not yet commissioned. Can we deal with that so we can just allocate an exhibit number to it?
Yes, what I've done is I've actually attached it to the new affidavit that I've handed up. I thought it would be easier to refer it, and I have referred to it in the new replying affidavit.
All right, so
it won't need another annexure, another number. It will be part of Exhibit B.
So it wasn't an affidavit per se, it's just an additional attachment.
An attachment, correct,
right,
which had to be commissioned because it was part of the affidavit, but for some reason it was left out. But I've now attended to that.
All right, thank you. Then you can attend to this replying affidavit.
It reads as follows, Your Worship. It's the Specialised Commercial Crime Court for the Regional Division of Gauteng, held at Palm Ridge, which is Court 7 today. It's case number 78 of 2020. In the matter between the state and Vincent George Smith, accused 1, Euro Blitz 48 Pty Limited, accused 2, Angelo Agrizzi, accused 3. And it reads as follows. It's a replying affidavit. I, the undersigned, Angelo Agrizzi, do hereby state under oath as follows. The contents herein are within my own personal knowledge, and unless indicated to the contrary, are to the best of my belief and knowledge both true and correct. I have been handed the affidavit of Colonel Lazarus just prior to the matter proceeding, and wish to set out in reply briefly the following. In or about 2006, I suffered from a severe heart attack, and then...
Sorry, I just want to hear, I hear you say 2006.
2016, sorry.
16, thank you.
I suffered from a severe heart attack, and it's been added in writing by Mr. Agrizzi on the original. I've also given it to my learned friend. If I can just maybe swap with him, as I hadn't written on mine, and I made sure that it was also affidavitted and commissioned. And after the severe heart attack, it's a constriction of the arteries of the heart and a flooding of the lungs. It was related to a heart tumor. I was revived twice on the operating table. And in fact, it was in December. It was just, I think it was Christmas Day, or it was on Christmas Day. I was revived twice on the operating table. I thus felt it necessary to transfer a sum of money to my common law wife's name in order to protect our money. I reiterate that the said transfer was done out of concern for my ill health and was done in normal course and many years prior to my arrest on the 6th of February 2019. On or about the 19th of February 2018, I transferred an amount of approximately 6 million rand to an offshore account with Reserve Bank approval. In or about November of 2018, I transferred the motor vehicle, being a BMW X6, into my common law wife's name. The above transaction was done at arm's length. The reason for this was in order to protect my wife and family as a result of my medical condition. And there's one other aspect which we'll deal with, which Your Worship will see, is that when he gave evidence last year, and we deal with this at the Zondo Commission, all the banks that he dealt with previously, all his accounts and everything was frozen and stopped. The banks refused to do any business after his disclosures. So this was all done in order to protect that as well as his family. On or about the 19th of January 2019, an amount of approximately 1 million rand was transferred by me to a law firm dealing with a property that had been purchased. All this was done in terms of the law and the relevant regulations. I confirm all transfers were done in accordance with all the relevant laws and regulations. I have correctly declared approximately 2560 in South Africa. I previously divorced my wife in the early years. However, we subsequently, after the divorce, we'd gone through, reconciled our differences, and we've remained together as common law man and wife in a universal partnership. And as you saw in the previous affidavit, this is for the last 28 years. I did trade in cryptocurrency in order to try and enhance my income, and all this was done legally and openly. I was due to travel overseas in 2019 after my arrest, and Colonel Lazarus approved same and had no objection to returning my passport. However, I was later requested by the State Capture Commission, the lead investigator, Mr. Frank Dutton, not to travel as I still needed my assistance and input, and I accordingly cancelled all my travel plans, which caused me financial loss both business-wise and personally. And I might just add, he'd already paid and he'd given them copies of the tickets and the travel plan, and with the cancellation he had to pay. The State Capture said to him, please, we need you, please cancel all your travel plans. The aforesaid travel plans were business and partially leisure related. I deny that I furnished any false information in the bail proceedings, and I further provided proof to the prosecutor from the Director of Public Prosecutions, Advocate Ceruni, of the loss of my Italian passport. I further disclosed at my bail application on the 6th of February 2019 that I was the holder of an Italian passport. I further wish to bring to the attention of the above honourable court that the reason why the vehicles were transferred was, firstly, after I'd given evidence to the State Capture Commission, all my bank accounts were both frozen and stopped by all the banks I was dealing with. I deny that I've misrepresented in any way the value of my assets, and I further declared these assets to the South African Revenue Services, where I've attended various inquiries in order to assist them. I deny most emphatically that I'd in any way disposed of any assets. I state further that I've been in constant negotiations with the bondholder of the residence, that's his present residence, and they required the property to be sold on auction. The said transaction, however, did not go through, and the property is still registered in the Agrizzi family name, and I still reside there. I further confirm that the loss of my Italian passport was disclosed to the state, and I submitted further an affidavit to them setting out the position and the fact that it had been reported to the Italian consulate. I state further, I have not and will not apply for any passports or travel documents. I will abide by any further conditions that the above honourable court might impose. I am further appearing on the 16th of October 2020 in the Specialised Commercial Crime Court in Pretoria. I have further been requested by the Honourable Deputy Chief Justice Zondo to appear again at the State Capture Commission in regard to further applications and evidence that they require. I would further respectfully request the above honourable court to take into account that had I not come forward as a whistleblower in relation to various acts that were being committed by Bosasa and African Global Operations, the late Mr. Gavin Watson, including the information and evidence that I gave relating to the present matter, at enormous risk to both my own life and the safety of my family, many of these cases would not even been investigated in order to assist the public and citizens of the Republic of South Africa in regard to what was going on. At no stage and in all my dealings with Colonel Lazarus, the investigating officer, and or captain, it should be Nevin, not Levine, it's a typographical, it's N-E-V-E-N, Your Worship, has there ever been any indication in view of the assistance that I've given them, including intending to provide them with a warning statement, that they would be in any way opposing bail. I further respectfully submit that Colonel Lazarus can investigate any further aspects, and I'm willing and able to assist him with any further queries in relation to the matter, in relation to any other aspects. Unfortunately, also due to my comorbidities and my present health condition, I'm now permanently under medical care and attention. And then what we've done, Your Worship, we've attached the letter, which is referred to by the state, that was sent on the 22nd of August 2019. We notified the state on the 2nd of August, Advocate Ceruni from the Director of Public Prosecutions, and on the 22nd of August we showed him the proof that it had been reported to the Italian consulate, the loss of the passport. And I would just like to read it into the record. It was sent to the Italian consulate in Johannesburg. The subject was A. Agrizzi, YB 3402359, which is the number of the passport. Dear sirs, this is from Daniel Witz, the attorney. I confirm that we represent Mr. Angelo Agrizzi. Mr. Agrizzi has requested us to contact the Italian embassy on his behalf. As of February 2019, Mr. Agrizzi was the holder of an Italian passport, which was issued to him by the Italian Consulate General in Houghton, Johannesburg. Mr. Agrizzi, despite an intensive search of his house, has lost his Italian passport. He has not been able to find the said passport. In view of the loss of the passport, Mr. Agrizzi, through his legal representatives, has requested that we contact the Italian Consulate General in Johannesburg and inform you of the loss. Kindly confirm in writing the noting of the lost passport. We await to hear from you. The reason this was done, Your Worship, is because when he reported it to the police said we're not here to deal with lost passports. Go to the embassy or the consulate, report it to them. So he wanted to report it as well to the police, and we were informed that this is the position, and Advocate Ceruni was informed. And not only that, Your Worship, He requested that Mr. Agrizzi go on oath and make an affidavit confirming his facts, which he did last year in August, and this was provided to the state. And there's never been any indication, Your Worship. They seem to suggest and allege that because of COVID-19 they didn't bring any application to withdraw the matter or the bail in Pretoria. I've been in constant contact with them. We've appeared on many occasions. There's been no problems at all. And if Advocate Sarunia was of any need to apply to either bring an application to cancel, withdraw, or change conditions or amend conditions, he's had since last year, 2019, not 14 months later, to now come along and say they want to bring this application. And they had all the proof, and we notified them, we notified the consulate, and we made it freely available that they're free to contact the consulate. And Mr. Agrizzi also confirmed to them that he would not apply for any new travel documents, passports, or anything of that nature. So we respectfully request that this be marked Exhibit B together with the annexure, which is the letter. Your Worship will just note that very kindly the Senior State Advocate allowed us to use his printer, so I've given it to you in full, so that's why you'll see his name on top and today's date, but you'll see the date of the actual email and the reporting. So I've given it to you in whole, so you've got the full document. But it wasn't done today, the 14th of October, the reporting. It was done last year. And the state were aware already in, I think, prior to August 2019, so it's more than a year ago, about 14, 15 odd months ago of the position. If the court is satisfied, I'd ask that this be marked Exhibit B and form part of the case and part of the record in regards to the bail application for my client, Mr. Agrizzi, who appears before you. Thank you, sir. If you can just confirm with him.
Thank you, Mr. Agrizzi. Did you understand? Did you understand the content of this replying affidavit reading to the record on your behalf?
Yes, I do.
You confirm the correctness of each and every fact contained therein?
Yes, I do.
Thank you. The court will receive this replying affidavit as Exhibit B to the record.
As court pleases, Your Worship.
Mr. Witz, any additional evidence that you wish to adduce, or is that your application?
No, that is my application, Your Worship. It's Exhibit A and Exhibit B. Thank you. And then I don't know what, if anything, further. So obviously I'd like to just reserve my rights, because as we stand here now today, on the 14th of October, besides this complete turnaround and what I've already addressed the court on, I don't know what further will come up. As I say, normally colleagues, if you intend doing something, you give it to your colleague and say, I'm taking this point, or I'm going to argue this, and this is the law, or this is the position, would you like to deal with it? Have you got an answer? Have you got a document? So I'll obviously just have to reserve my rights, because maybe there's new surprises, or maybe there's something new that we don't know about or we've not been made aware of. So if I could just reserve my rights and my client's rights in terms of the Constitution, Act 108 of 1996, Section 35, as well as his legal rights to reply if necessary. Other than that, that would be our case.
Let's hear the respondent, and then you can consider your options and inform me of what you intend to do.
Yes, I will, once I've heard. As I say, I don't know, because there's been no candidness and openness with the court, unfortunately, and with my colleagues. So unfortunately, I'm in that position. I would have loved to have known beforehand So I've dealt with it as best as I could in the time that I've been given, but I'd like to just reserve that right in case something new comes out the woodwork.
Thank you.
Thank you.
Thank you.
Thank you, Worship. Your Worship, I'm indebted to the court. Your Worship, Mr. Wits and the state, Your Worship, always had this cordial relationship, which is based on mutual respect. Your Worship, the attitude of the state changed this morning when we received an affidavit from Mr. Wits. Both the state, Your Worship, and Mr. Wits never had an opportunity of exchanging.
Please, I'm going to ask you, it's for your protection and for our protection.
Thank you, Your Worship.
Thank you.
We never had the opportunity of exchanging the affidavit until this morning. And Your Worship, both the movable and immovable assets are the most important thing in the bail closed. When we read the affidavit of the accused, Your Worship, 33 million of assets that are overseas were never disclosed. And they were not disclosed on the previous bail application. Your Worship, my colleague is a senior counsel. That information can never be non-disclosed or can be kept aside and not disclosed in the affidavit. And Your Worship, our attitude changed after that, and we decided that we are going to oppose the bail application. Your Worship, further, the accused has a property which is in Krugersdorp. We realized only a day before yesterday that the property was actually sold on public auction. Also, that made us to change our attitude. So, Your Worship, there was never a situation where we did not want to inform Mr. Wits, but we felt that it is actually important that the accused should have actually disclosed all the information. And when we realized that in his affidavit this morning that he did not disclose the information, therefore we decided we are going to oppose bail, Your Worship.
With your
Thank you, Your Worship. My colleague,
proposal?
I'm going to request that Advocate Rousseau, Your Worship, who's actually also on record, reads the affidavit on record, Your Worship. Thank you.
Thank you, Your Worship. Your Worship, I will preliminarily hand up the affidavit we will be reading out, as well as a draft order that we also drafted in anticipation, well, for the court to use if the court were to decide that bail is in order. Thank you, Your Worship. Your Worship, in opposing this application, the state intends to hand up the affidavit of Colonel Bernardus Lambertus Lazarus. I will proceed to read out the content thereof. Bernardus Lambertus Lazarus hereby state under oath, I am a Lieutenant Colonel in the South African Police Service with service number 04295442-2. I'm stationed at the Serious Economic Offences Unit, Commercial Crime, and Directorate of Priority Crime Investigation at 83 Steve Biko Street, Arcadia, Pretoria, and then he lists his contact information. I'm currently seconded to the Investigating Directorate proclaimed by the President of the Republic of South Africa in terms of Section 7.1 of Act 32 of 1998, Proclamation 20 of 2019, Government Gazette 42383 of 4 April 2019. I am the Investigating Officer of Police Case Docket referenced Pretoria Central Case 1556/02/2010. In the aforementioned matter, the applicant in this matter was arrested on 6 February 2019 and appeared in the Specialised Commercial Crime Court, Pretoria. On 6 February 2019, the applicant filed an affidavit in the aforementioned court in support of his bail application, which is attached hereto as Annexure A. Based inter alia on the content of the affidavit as per Annexure A, the prosecutors and I did not consider the applicant to be a flight risk, and he was therefore released on bail to the amount of 20,000 rand. Paragraph 7. The following factors in Annexure A were taken into consideration in this regard. Bishop, may I state that, or point out that the contents of the paragraphs I am to read out now is verbally the same as in the present application. In paragraph 8.2 of Annexure A is stated, I reside at 97 Helderfontein Estates, where I have resided for the past 5 years. I own the property, which is valued at 13.5 million. The property is bonded with ABSA on a revolving credit, and I still owe an amount of approximately 8.1 million on the property. Attached as Annexure B is a copy of my bond documentation. In paragraph 8.10 of Annexure A is stated, my wife and I own movable assets at approximately 2.65 million and immovable property valued at approximately 14 million. 7.3. In paragraph 17.3.2 of Annexure A is stated, section 40 in brackets 4 in brackets small b, where there is a likelihood that the accused, if he were released on bail, will attempt to evade his trial. I will stand my trial and have no inclination whatsoever to avoid my trial. I submit that the fact that my legal representatives as well as myself have been in constant contact with entities of the state is indicative that I have no intention to abscond. Paragraph 7.4. In paragraph 17.3.6 of Annexure A is stated, other relevant factors to be considered by the Honourable Court. I am a South African citizen with strong emotional ties in the Republic of South Africa, and I have given my full cooperation with the arresting officers and all the people involved. I have fixed property which I cannot afford to lose. Save for the last sentence, Your Worship, as I stated before, this is basically verbally contained in the current application. In respect of paragraph 7.1 supra, that's in paragraph 8, I need to point out that a copy of a bond documentation was not attached as Annexure B to Annexure A. In paragraph 9 it goes further in saying, since February 2019, further evidence has become available or factors have arisen, including the fact that the applicant has furnished false information in the bail proceedings, which might have affected the decision to grant bail in that matter. Therefore, the prosecutors intended to file an application in terms of Section 68 of the Act 51 of 1977 in respect of an applicant. However, due to travel restrictions imposed in terms of regulations made under Section 27(2) of the Disaster Management Act 57 of 2002, the application in terms of Section 68 of Act 51 of 1977 has not yet been brought. Lord, in this respect, I might just mention that due to the travel restrictions, it would not be necessary to incarcerate Mr. Agrizzi at the time, because he would not be able to leave South Africa during this time. So therefore, such an application has not yet been brought. Back to the affidavit, Your Worship. The following factors will be relied on the aforementioned intended application, and it's also indicative of the applicant being a flight risk in the current matter. 10.1. Contrary to what was stated in paragraphs 8.2 and 8.10 of Annexure A, this is now, neither the applicant nor his wife have immovable property registered in their names. The following properties are, however, registered in the name of the Agrizzi Family Trust with registration number IT 3870 of 2013. 10.1.1 ERF 97 Riverside View Extension 6. The property was purchased on the 5th of December 2014, bearing the purchase price of 10.3 million. A mortgage bond in the amount of 8.7 million was registered over the property in favour of Absa Bank Limited. 10.1.2 ERF 489 Marula Dal Extension 23. This property was purchased on the 6th of November 2016, bearing the purchase price of 2.2 million. 10.2. Although the applicant is one of the beneficiaries of a trust, the trust is a separate entity. The applicant can therefore not legally claim ownership of trust property. The trust deed explicitly describes capital beneficiaries of a trust as the beneficiaries on whom the trust capital will devolve during the currency of trusts or on termination thereof in terms of the provisions of a trust deed, and which beneficiaries shall be selected by the trustees in their discretion from the ranks of the beneficiaries identified. Your Worship, for the record, this is from the trust deed of the Agrizzi Family Trust that we're quoting. Paragraph 10.2.2. Paragraph 22.1 of a trust deed states, until any benefit or reward vests in a beneficiary, nothing herein contained shall create or confer upon any beneficiary any right or claim to benefit or award delivery of any assets thereunder. 10.2.3. Paragraph 22.2 of a trust deed starts with the following statement. No rights or hopes of beneficiaries under this trust and no part thereof shall be attachable by any creditor or any beneficiary or vest in his trustee in insolvency. 10.3. In respect of the movable assets contained in paragraph 8.2 of Annexure A, the applicant failed to disclose the following. 10.3.1. He is/was married to Deborah Agrizzi out of community of property, profit or loss with exclusion of a accrual system. And I received information that the applicant and Deborah Cindy Agrizzi may be divorced and will follow up on that. Your Worship, in this regard, we may just mention that according to the Department of Home Affairs, Mr. Agrizzi and Deborah Cindy Agrizzi is now applicant, and DC Agrizzi got divorced on the 5th of July 1996. What caused some confusion is that Colonel Lazarus came across an anti-nuptial agreement dated 2004 that was submitted to the bank, and it was obtained through a 205 at Absa Bank. So that caused some confusion as to whether or not Mr. Agrizzi and DC Agrizzi was indeed married. Not that it makes a huge difference, Your Worship, but just to clarify what happened exactly there. And now we've been informed that indeed Mr. Agrizzi, or the applicant, and Mrs. Agrizzi has been divorced, and they are having a common law marriage. Now, on 6 February 2019, this is now paragraph 10.3.2, that's the date of the previous bail application. The applicant had no vehicles registered in his name. He transferred ownership of the following vehicles to Deborah Cindy Agrizzi. A Ferrari F360 Modena with vehicle license number MOD 360 GP. This vehicle transferred on the 13th of September 2018. Colonel Lazarus goes further as to state that in February 2019 similar vehicles were marketed for between 1.5 and 1.7 million. He then goes further and says this vehicle appears to have been sold or traded in on an X5 BMW with vehicle license number JK77GP, a JSN BMW on 11 February 2020. Then the next vehicle is a 2017 BMW 760 Li with vehicle license number HP68BY GP. The date of this transfer was then the 10th of September 2018. In February 2019, similar vehicles were marketed for between 1.35 million and 2 million rand. Ownership of this vehicle, however, was transferred back to the applicant on the 1st of February 2020. Now, the next point is more important. Between 11 December 2018 and 19 January 2019, the applicant transferred a total of 11.96 million to offshore accounts as a foreign investment by a resident individual in respect of the investment allowance. Now, to break this up, between 11 December 2018 and 14 December 2018, 10.96 million rand was transferred to offshore accounts in the name of the applicant. On the 19th of January, a further amount of 1 million rand was transferred to an offshore account named Studio Notaio Antonio Zorzi. According to the website www.studionotarile Zorzi IT, it appears to be a law firm dealing with transfer of real estate in Siena in Italy. Now, that's as far as the applicant's concerned. Paragraph 10.3.4 deals with Deborah Agrizzi, the applicant's common law wife. Between 21 December 2018 and 3 January 2019, Deborah Cindy Agrizzi transferred a total of 11.99 million to offshore accounts as foreign investment by a resident individual in respect of the investment allowance. On 21 December 2018, 996,113 rand was transferred to an offshore account in her own name. On 2 and 3 January 2019, a further 11 million was transferred to an offshore account styled Studio Notaio Antonio Zorzi. 1 million rand was transferred from her FNB account and 10 million from her Netbank account. This followed a transfer of 10 million, two transfers of 5 million each from her FNB account on 29 December 2018, received in her Netbank account on 19 and 31 December 2018 respectively. This, the importance thereof will become apparent a bit later, Your Worship. Well, the aforementioned funds originated inter alia from payments to her FNB account with a reference Ferrari to the amount of 7.975 million on 28 and 29 November 2018. Payments to her FNB account with reference BMW X6 to the amount of 1.05 million on 13 and 14 December 2018. 8 million transferred from the applicant's ABSA private banking account on 28 November 2018. R25,000 transferred from the applicant's ABSA private banking account on 13 December 2018. 50,000 transferred from the applicant's ABSA Private 1 account on 13 December 2018. 1.945 of 1,945,200, yeah. Let me get this right. I think there's too many zeros here. It's
Thank you, Worship. If it's extra, we'll take it.
This is not 1.9 billion, Your Worship, 1.9 million. 1.945 million transferred to the applicants. If we can just delete the last 3 zeros, Your Worship, transferred to the applicants' Nedbank account on 15 to 21 December 2018, and 2 million transferred from the applicant's ABSA 1 account on the 27th of December 2018. Now, Your Worship, as I will show later on, this then indicates that the source of the funds, and that's the relevance of this, the source of the funds that Deborah Agrizzi transferred to Italy was the applicant, safe for 1.05 million that she received in her account for payment for the X6 BMW. We will deal with this a bit later. So that's the importance of this paragraph. The source of the funds that she transferred originated from the applicant in this matter. Now, Worship, now on 6 February 2019, that's now the date of a previous application in the other court. DC Agrizzi and the applicant had the following positive balances totaling 8.75 million in various bank accounts, and this excludes an ABSA credit card and Standard Bank accounts which we still have outstanding. I will list it as follows: 4.238 million in an American Express account, that's a credit card account, with a positive balance of 4.238 million. 27,284 rand and 93 cents in an ABSA private bank account. 493,206 rand and 35 cents in a Nedbank account. That's all Angelo Agrizzi, the applicant. Then 1,025,000 and 133 rand and 14 cents in a Nedbank account for DC Agrizzi. 247,530 rand and 37 cents in a Nedbank money trader account for the applicant. 22,338 rand and 80 cents in an FNB card for the applicant. 404,218 rand and 97 cents in an FNB wealth account for the applicant. 295,105 rand and 12 cents in an FNB private wealth account for DC Agrizzi. 585 rand and 41 cents and 1,426 rand and 22 cents respectively in an ABSA depositor plus account for A. Agrizzi. And then at least 2,001,540 rand and 14 cents in an unknown account or location. This amount was deposited to his Nedbank Money Trader account on the 7th of February 2019. So that's why we know it was there somewhere. Your Worship, it's therefore clear, that's paragraph 10.4, that the applicant misrepresented the value of movable assets belonging to himself and his wife significantly in paragraph 8.2 of Annexure A. As illustrated above, they had liquid assets, and that's cash at hand, of at least 8.576 million rand in local bank accounts or in cash. And on top of that, offshore assets to the value of at least 24 million, which was confirmed to be liquid assets in December 2018 and January 2019, as well as vehicles with a retail value of at least 2.85 million. And these amounts then, this amounts to a combination of movable assets, excluding household furniture, jewelry and art, of 35.6 million instead of 2.65 million as declared. Worship, just to get back, the significance of this remains the 24 million foreign assets, foreign liquid assets, that was not disclosed at the time. May I add, Your Worship, that today again, when the bail application was brought, no word about the foreign assets was included in that application. And as my learned colleague rightly pointed out, once it became clear that the applicant again chose not to take this court into his confidence and disclose his foreign assets, the state had no option other than to oppose his application.
Mr. Rousseau, can I ask you to confine yourself to the reading of the affidavit?
Oh.
You can retain your closing arguments for a later stage.
I apologize.
Otherwise, we are clouding what is written in the affidavit against what you are now making submissions from the law.
I apologize, Your Worship. I will refrain from doing that. Your Worship, then paragraph 10.4. The payments to the FNB account of Agrizzi, DC Agrizzi with reference Ferrari and BMW X6 as per paragraph, and Your Worship, can we just amend the affidavit? There is a mistake. It's supposed to refer to paragraph 10.3.4.3, not 7.2.4.3. Payments to these accounts appears to be consistent with the disposal of assets at the time. Payments with a reference Ferrari to the amount of 7.975 million and on 28 and 29 November 2018 appears to relate to the sale of a 2014 Ferrari F12 and the 2016 Ferrari 488 GTB registered to the Agrizzi Family Trust. 10.5.2 payments with reference BMW X6 to the amount of 1.05 million on 13 and 14 December 2018 appears to relate to the sale of a BMW X6 registered to DC Agrizzi. Paragraph 10.6. Contrary to what was stated in paragraph 17.3.6 of Annexure A, the applicant does not really seem to care whether he loses the fixed property he claimed to have. This is clearly demonstrated in his conduct before and after his arrest. 10.6.1. The property referred to in paragraph 8.2 of Annexure A is bonded by ABSA as collateral for an ABSA 1 account in the name of the applicant. Although the property is bonded for 8.7 million, the facility granted was only 7.96 million. The facility was reduced from 10 million to 7.96 million on 17 August 2017 following the release of Unit 47 Savannah, ERF 166 Simbiti, Durban, as collateral for this facility. In terms of paragraph 13 of a facility letter dated 13 January 2015, the applicant will be in default of the agreement if inter alia he does not pay any amount payable to ABSA in terms of this agreement on the due date. On January 2018, the account had a positive balance of 43,182 Rand and 36 cents. On 17 November 2018, the applicant owed 7,918,340 Rand and 59 cents, whereafter he transferred 7.92 million into this account on 27 November 2018. And then between 1 December 2018 and 24 January 2019, this account was again overdrawn to the amount of 7.53, let me do this again, 7,953,959 Rand and 52 cents. The last payment to this account was honoured on the 1 February 2019. Since then, the account has been mostly dormant. I was informed that the outstanding amount as on 12 October 2020 was 9,045,149 Rand and 62 cents. And this amount is expected to exceed the potential realizable value of a property in current market conditions. The aforementioned amount exceeds the total facility granted by more than 1.1 million. In the period 1 February 2019 to date, large amounts of money was moved to offshore accounts and to cryptocurrency accounts, but the applicant chose not to make payments to this account. The aforementioned is significant given the fact that according to the applicant, he earns a gross salary of 55,000 Rand per month, being his only source of income as on 6 February 2019. This was not even enough to cover the monthly interest commitment of 58,105 Rand and 4 cents as on 6 February 2019. He then goes further and says, I was informed that ABSA is finalizing papers to launch proceedings for the recovery of the outstanding amount and declaring the property executable. .7. Since 6 February 2019, the following transactions occurred, clearly indicating that the applicant had no intent to service the debt as per paragraph 10.6. On 11 February 2019, the applicant transferred 2.15 million from his Nedbank money trader account to his Nedbank current account, and then transferred 2 million from his Nedbank current account to the Nedbank account of DC Agrizzi. On 27 February 2019, the applicant transferred 2 million from his American Express account to his Nedbank current account, and from there transferred 1.89 million to a Luno account. In brackets, Luno is a cryptocurrency exchange. On 1 March 2019, the applicant transferred 1 million from his American Express account to his Nedbank current account, and from there 900,000 rand to the Nedbank account of DC Agrizzi. On 4 March 2019, the applicant transferred 1 million from his American Express account to the Nedbank account of DC Agrizzi. He received information that on 5 March 2019, the applicant bought real estate / properties in Castel del Piano in Italy for €880,000. The contract in that respect was registered on the 6th of March 2019. On 10 April 2019, DC Agrizzi closed the Nedbank account and transferred the balance of R4,455,458.06 to her FNB private wealth account. On 1 April 2019, DC Agrizzi transferred R2,175,850 from an FNB private wealth account to the Luno account mentioned in paragraph 10.7.2 supra. On 22 July 2019, DC Agrizzi bought foreign currency to the value of R99,936.26 on a foreign travel allowance. From 3 to 7 October 2019, DC Agrizzi transferred a total of R774,515.61 from a Standard Bank account to offshore accounts in the name of Angelo Agrizzi as gifts and payments for cultural and recreational services. On 10 October 2019, DC Agrizzi transferred an amount of R205,480 from a Standard Bank account to an offshore account or accounts in the name of DC Agrizzi as payment for cultural and recreational services. The conclusion follows, Your Worship, wherein he says, whereas a total of 6.69 million was transferred either offshore or to a Luno and altcoin cryptocurrency exchanges, then transferred to unknown recipients' locations, and the bond is not serviced at all, it's respectfully submitted that the applicant is prioritizing offshore assets and has no intention to secure the property referred to in paragraph 17.3.6 of Annexure A. Paragraph 10.8. The transactions on the Luno account as referred to in paragraph 10.7.2 and 10.7.7 for the period 28 February 2019 to 21 May 2019 can be summarized as follows. Transfers totaling 1.89 million was reflected in this account on 28 February 2019 to 1 March 2019. From 1 March 2019 to 8 March 2019, cryptocurrency to the value of 1.89 million was purchased. The transfer of 2,175,850 was reflected in this account on 12 April 2019. On 12 April 2019, cryptocurrency to the value of 2,174,750 rand. I see I've got million on the affidavit. Worship, it is rand, it's not million. I repeat, it's 2,174,750 rand was purchased. On 13 April 2019, from 13 April 2019 to 2 May 2019, cryptocurrency to the value of 1,460 was purchased, and on 20 May 2019, cryptocurrency to the value of 23,100 176 was sold for cash and transferred to the FNB account of the applicant. Paragraph 10.8.6. Between 10 April 2019 and 15 April 2019, Ethereum to the value of 260,249 Rand and 84 cents was sent to an unknown recipient or location. This is cryptocurrency. Paragraph 10.7. Between 10 April 2019 and 18 April 2019, Bitcoin to the value of 4.5 million was sent to an unknown recipient or location, whilst Bitcoin to the value of 525,000 was received into the account on 14 April 2019. I furthermore received information that between 16 August 2019 and 5 October 2019, an amount of 854,616 Rand and 80 cents was deposited in an altcoin trader account opened by the applicant, and that the funds was converted to Bitcoin that was sent to various Bitcoin wallets. We are on the process of verifying this information. I also received information which will be verified by means of mutual legal assistance with the Italian authorities once we are able to do so, given the current COVID-19 crisis. The applicant operated a bank account with Intesa Sanpaolo SPA in Italy with an account number IT49 R0306914226 1000000001901. The account was opened on 12 November 2018, and Ms. Deborah Cindy Agrizzi was delegated to operate the account as from 15 March 2019, and the account was closed on 24 October 2019. The applicant, this 10.2, the applicant received significant transfers from his South African bank account during 2018, whereafter 488,000 euro was transferred to the Italian bank account of Ms. Deborah Cindy Agrizzi. During April 2019, significant bank transfers were received in this account from an Estonian account at CB Payments Limited, a cryptocurrency platform. On 5 March 2019, the applicant bought real estate properties in Castel del Piano in Italy for 880,000 euro. Contract in that regard was registered on the 6th of March 2019. Ostensibly, a luxury car was purchased as well. 10.10.5, DC Agrizzi reportedly also operated her own bank account under account number. I'm not going to read this out, Your Worship, with permission of the court. Intesa Sanpaolo SPA in Italy. As on 30 March 2020, the particular bank account had a balance of 714,000 euro. 714,419 euro and 50 cents. Following a request to travel by the applicant, this is now paragraph 11, in July 2019, the prosecutors inquired from me whether the applicant surrendered his Italian passport to me. At the time, I was not aware that the applicant had an Italian passport, and it was not mentioned when the applicant's South African passport was handed over to me as part of his bail conditions. Whereas the applicant would be in breach of his bail conditions for not handing in this passport, the matter was taken up with his attorneys to Wits Incorporated. On 2 August 2019, the prosecutors received a letter from Mr. Daniel Wits, wherein he stated that the Italian passport was lost. This was also conveyed to me by Mr. Wits telephonically, but it was the first time that the loss of the Italian passport was conveyed to me. The aforementioned letter was followed up by an affidavit by the applicant dated 15 August 2019, wherein the following was stated. My Italian passport was lost, and after the extensive search of my house, my study and my belongings, my motor vehicle, and I have not been able to find the said passport. After my sudden and completely unexpected arrest, and whilst I was still in the process of assisting and testifying before the State Capture Commission, I did not report the loss of a passport to the Italian Consul General. When my legal representatives received correspondence from Senior State Advocate P. Serunye, may I just mention, rather leave this, in relation to the Italian passport, I again searched for the passport, and my legal representatives informed him that the passport has been lost. In view of the loss of a passport, I, through my legal representatives, will contact the Italian Consulate General in Johannesburg, inform them of the loss, and I will forward a copy of a correspondence reporting the loss. Colonel Lazarus then, this is like Colonel Lazarus continuing. I respectfully submit that the loss of our Italian passport in conjunction with the facts set out in paragraph 10 is suspicious, especially given the fact that I was not informed of a loss in February 2019, as on 15 August 2019, Italian authorities was not informed of a loss either. In this regard, I need to clarify that I was not aware of the fact that paragraph 7.5, where Mr. Agrizzi declared that he was the holder of an Italian passport, was inserted in pen in Annexure A, and I therefore did not inquire about the whereabouts of the Italian passport. Paragraph 12. I am now of the opinion that the applicant indeed poses a flight risk, as he has a means of leaving the country, and he chose to mislead the Specialised Commercial Crime Court, Pretoria, on 6 February 2019, as per Annexure A, in that he failed to mention his offshore assets. I am made to understand that if the applicant were to abscond to a foreign country, extradition proceedings would have to be followed, which can be an expensive and protracted process, especially if it's opposed. I am therefore not convinced that it will be in the interest of justice for the applicant to be released on bail. At the time of deposing to this affidavit, I have not seen an affidavit by the applicant in support of a bail application in this court, and I undertake to prioritise investigations into any new averments contained in such affidavit, if so needed, and to revert to this court as soon as possible. Worship, this affidavit was then attested to today, the 14th of October in Johannesburg. I will then hand this up as Exhibit C. Sorry, I'm informed the last exhibit was Exhibit H. So this would be Exhibit I. J. So
No, you were misinformed. The last exhibit was B.
Was it B?
Yes.
This application was, in this specific application obviously it's B, yes. So this would then be Exhibit C.
I'll allocate an exhibit number to it in a moment.
Thank you. Thank you, Your Worship.
the affidavit by the respondent made by the investigating officer, Lieutenant Colonel Lazarus, is received and marked Exhibit C to the record.
As the court pleases.
Thank you, Your Worship. Worship, my colleague will then proceed with the application. Cool. So, Your Worship, this is in this, as far as our reply to the application is concerned. May I just add that the ill health of the applicant is not in dispute.
Right. I will permit you an opportunity for final closing address. Can we just conclude, is this the only evidence that you wish to adduce in opposal?
Indeed, Your Worship.